Former President Jacob Zuma wants the State Capture Commission chair, the Deputy Chief Justice Raymond Zondo, to recuse himself. Zuma said he would not appear because he believed Zondo had already decided that he was guilty of all allegations against him. A couple of important questions here. Where does this leave the Commission, and is Zuma on firm legal ground? Professor Pierre de Vos joins us now from the University of Cape Town. He teaches in the area of constitutional law. Professor, good afternoon to you. First of all, let's just look at the law simply if we can. If anyone refuses to appear before a commission, he is in contempt. What happens then?
Well, if you only in contempt if you are summoned, and then unless you have just cause not to appear, then you are convicted of a criminal offence. You have to pay a fine or up to 6 months imprisonment. I think the current situation is, of course, to try and create that just cause, to say the former president doesn't have to adhere to the summons because he has just cause not to do so, and that just cause, he will argue, is that the chair must recuse himself because the commission is biased against him.
That phrase, just cause, is it legally tricky? Is it open to different forms of interpretation?
It is open to interpretation. It is clear that a just cause doesn't mean any cause or just something that you invented. The court has said that that will be interpreted in each context, taking into account the rights of the person appearing and so on. So whether in this case it will be helpful, I'm not so sure.
Professor, the legal team of Jacob Zuma is accusing the Deputy Chief Justice of, and I quote, bias and prejudging. I wonder how they would arrive at that interpretation, and perhaps more interestingly, how do you prove it?
Well, I think this is actually really more of a political argument than a legal argument, because the case is happening on two fronts. The one is a legal fight, the other one is the fight for perceptions. So it's more helpful for the political fight for perceptions than for the legal argument. You have to show the test in law for recusal, although we don't know if it actually applies to the Commission, because the Commission is not a court of law. They don't make findings that are binding. So whether the same test applies, I'm not so sure. But if it did, the question is, what would a reasonable person think? Would a reasonable person be fearful that the chairperson or the presiding officer cannot be impartial? And the court has said that is not an easy test to meet. It is not a test that will be applied in terms of somebody who is overly suspicious or paranoid or whatever the case might be. It will be somebody with all the facts. And so you make an objective assessment of what a reasonable person would do or feel. And so what they will do, they will go and look at his statements, and they're going to make all the arguments that because the Commission tried to get him to come and testify, that show that they are biased, because they are trying to humiliate him by forcing him to testify and to give responses to all the people who implicated him in corruption and state capture.
Is this challenging the integrity of the Commission?
Yes, so the Commission's integrity has been challenged in a way. It's one of the subtexts of President Zuma's legal defense, in the sense that integrity, in the sense that the legitimacy of the Commission is in issue. So because the Commission is not a court of law, it cannot make any binding decisions and findings. It stands and falls whether it is legitimate, whether it's persuasive, whether people believe it. And so this is not really a legal argument, it is a political argument.
There's no chance that the Deputy Chief Justice is going to recuse himself, surely?
I will be very shocked if he does. We don't, with one caveat, and that is that the former president hinted that there were some personal relationships and so on and so on. We don't know what they are. We don't know how serious it is. But even so, I suspect he's not going to recuse himself. Even the judges of the Constitutional Court, when they were asked to recuse themselves, one of them having President Mandela attending his son's wedding and President Mandela being one of the litigants, the court said, no, we are not going to recuse ourselves because no reasonable person is going to think this makes me incapable of being objective.
Is this a risky game that the former president is playing?
I think it's the only game in town, in the sense, and it might work in the sense that, as I said, this is not really about whether ultimately he's going to win the legal argument and the legal fight. There is a time ticking here for the end of the commission, and as long as he can prevent him from testifying until such time as the commission concludes its work, the strategy would have been successful, regardless what happens afterwards.
So it's all about running down the clock. Professor Pierre de Vos, thank you, as always, for the insight.